Today, we will discuss why filing any document, no matter how simple, with a Secretary of State without first obtaining attorney review is usually fatal and costly. But first, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications spanning accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. Savvy and sophisticated business owners routinely underestimate the serious danger of filing documents directly with a Secretary of State without having them drafted and reviewed by a competent attorney. What looks like a simple form on a state website is almost never simple. One misplaced word, one omitted document, or one procedural misstep can trigger federal tax disasters, state law penalties, loss of limited liability protection, or outright rejection that leaves the company in legal limbo. I see this happen all the time. Do-it-yourself filings and generic online templates are responsible for some of the most expensive cleanup projects I undertake on behalf of clients. Let's start with reason number one. Most Secretary of State provided forms are bare minimum shells or outlines. The articles of incorporation, articles of organization, certificates of conversion, and statements of domestication available on state websites are intentionally limited and bare bones. They are designed to satisfy certain statutory minimums, not to actually provide you with any degree of protection. They almost never require or include the critical non-optional documents that courts and the Federal Internal Revenue Service, or IRS, require for the transaction to be valid and defensible. In the state of redomestication, which is the moving of an existing business from one jurisdiction to a new state, that would include, for example, and among other documents, a properly drafted plan of conversion, a unanimous written consent or board meeting minutes adopting that bespoke plan of conversion, tax clearance language that prevents inadvertent dissolution or liquidation treatment, provisions preserving existing contracts, the federal employee identification number and liability shields, and several others. When you file these public-facing documents without these supporting instruments, many states will still accept and stamp your filing, then leave you fully exposed. The Secretary of State is not your lawyer. They don't give legal advice. They don't even review the documents to see if they really make sense. Their job is limited to revenue collection and record keeping. And if you don't believe me, call the Secretary of State and ask them. They will tell you that same thing almost verbatim. Reason number two, federal tax catastrophes lurk in the shadows, and no, that is not an embellishment or exaggeration. The IRS does not care that a Secretary of State accepted your document. Certain transactions, including, for example, conversions, domestications, and even some amendments, can accidentally be treated as taxable liquidations. Let me say that again, treated as taxable liquidations for the people in the back, or contributions to an entirely new entity, even if you are using the same name and federal employer identification number. A single DIY attempt can trigger, among other things, immediate capital gains recognition on appreciated assets, sometimes hundreds of thousands, or in some cases, even millions of dollars, loss of subchapter S status, loss of the federal employer identification number, and IRS and state tax audits triggered by mismatched or incomplete filings. Now, these are not theoretical risks. Law firms, including my own, routinely see 6- and 7-figure tax bills generated by the hubris of a business owner who thought that they could just handle it themselves because they knew the law, or by relying on an online service such as LegalZoom or Rocket Lawyer without understanding the reorganization provisions of the Federal Internal Revenue Code, including, for example, sections 368, 351, and 721. Reason number three, state law penalties and loss of liability protection. This is a big one. Many states, and Texas and Florida are particularly aggressive, treat the filing of false, incomplete, or fraudulent documents as a felony. Yes, you heard that right. Even innocent mistakes, such as representing that a conversion has been properly approved pursuant to a plan of conversion, when in fact the internal resolutions or plan never existed in the first place, can violate statutes prohibiting false filings. Operating afterward without proper authority can strip the company and its owners of the limited liability shield, thereby exposing owners to unlimited personal liability for business debts and lawsuits. That is a one-way ticket to bankruptcy court. Also, reason number four, secretaries of state reject thousands of DIY and online service filings every year for technical defects, particularly when these documents were not drafted by an attorney. Once rejected, the company is often stuck in legal limbo. The old state still considers it to be domiciled there and is still taxing it, while the new state has no official record. Fixing the problem usually costs, and I'm not exaggerating here, between 5 times and 25 times, yes, you heard that correctly, what proper counsel would have charged at the outset to get it right the first time. Reason number 5, generic templates and the current generation of AI, including ChatGPT, Gemini, Claude, and even Grok, routinely omit entire categories of required documents or invent fictitious procedures and state statutes. I saw it happen just earlier today. Following the advice of an LLM is the fastest way to create an expensive mess that experienced attorneys must later untangle at hourly rates far exceeding what would have been charged just to get it right the first time. Here's the bottom line. Saving a few bucks on the front end by skipping attorney review and preparation routinely costs business owners several orders of magnitude more on the back end in taxes, penalties, lost time, lost revenue, reputational damages, and corrective legal fees. The Secretary of State's online portal is a filing cabinet, not a law firm. Anything beyond the very simplest initial formation, which would include, among other things, amendments, conversions, domestications, mergers, ownership changes, and even registered agent updates in some cases, should be drafted and reviewed by a competent attorney licensed in the relevant jurisdiction before it ever touches a state database. In short, if the transaction is important enough to file with a Secretary of State, it is most certainly important enough to have a competent lawyer make sure it is done correctly the first time. The false economy and hubris of do-it-yourself approaches or the use of cheap online services in this arena is one of the most consistent destroyers of business and personal wealth in America. You know the insides and outs of your business, but unless you went to law school, passed the bar, and spent years building experience in this particular niche of the law, do not fool yourself. Be smart enough to recognize that you are not an expert on this. And hey, that's okay. We all have gifts, talents, and areas of expertise. This may be the only legal transaction you handle in your lifetime, but my law firm handles dozens every week, so why take the chance on a do-it-yourself? Again, my name is Chad Cummings, and I hope that you found this information helpful. It's certainly intended to be helpful and not condescending. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this important information or the content of any of my earlier presentations, please visit my firm website as www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.